Good evening, everybody.
Good evening.
All right. The first thing I want to do is always ask you if you have any questions. And since you never have any questions, because I have my handy dandy exit, I'm going to ask you some questions. I'm going to answer some questions. Because if I don't get these, I'll never get any questions. But guess what? There are a lot of questions in here. So that means that people have questions. And sometimes I wish you would ask them in class. There's one question in here that I just cried when I read it. Because I was like, oh. Well, I shouldn't put it up there. But I have a question. Well, somebody said, please explain ex parte. And it's sad because I don't think the person is here who asked me to do this. And there were like a lot of questions. So what happens when you don't comply with an ex parte? So there were a lot of questions about the ex parte. Ex parte is a procedure where you can go into court when the other party, you know, every lawsuit has a plaintiff or an applicant and a defendant or a respondent. When you go into court and the other party's not there, when you're going to ask the court something and the other party who you're asking the court is probably going to be against that person, like it was in the Apple case, that person is not there, then that's ex parte. Any kind of communication that you're having with the court when the other party is not present, that's ex parte. And we normally, you know, don't like to do it. You like to give other people notice of what you're going to the court to ask for. There are some situations, some emergency situations and some other types of situations where you can go ex parte. In some respects, you have to give them some kind of note. You got to call them on the phone and say, hey, I'm going to the court, so they can rustle up, get their lawyers or whatever. But there are some situations where, and we may talk about one today, where it is expressly a situation where you go into the court, where the FBI, the Department of Justice, they'll go into the court on an ex parte basis. So that's what ex parte means. Let's say that the Department of Justice, the FBI's lawyers are the Department of Justice. They're going to the court for a warrant, you know, against somebody that's doing terrorist activity. They're going to go in. They're not going to tell that person that they want to do a wiretap on it, so they're not going to tell that person. They're going to go into the court ex parte. That's what ex parte means. Okay, so I'm going to ask a person, the first person who will raise their hand. In that last class, when I talked about the Bill of Rights, I focused on one particular amendment. What amendment was that? Yes, ma'am. The Fourth Amendment. Remember we talked about the Apple iPhone? Talked about the Fourth Amendment. Let me see. All right. And remember, when we're talking about the Bill of Rights, we're talking about protection. So what protection is afforded to us from the Fourth Amendment? I'm looking for somebody different. From the Fourth Amendment. Yes, sir.
That's the protection from unlawful search and seizure, right?
Absolutely. Very good. It protects us from unlawful or unreasonable searches and seizures, okay? So, with that being said, for somebody else, what must law enforcement or the government obtain in order to conduct a search or a seizure? Yes, sir.
A warrant?
Yes. A warrant. So if, let's say the FBI, the government wants to get a warrant, what must they demonstrate to the judge in order to obtain that warrant? Yes, sir?
Reasonable cause.
Okay, I'm gonna give you credit for that, but what else can it be called?
Probable cause.
Probable cause. You gotta have probable cause. I want you to use that word, probable cause, because that's the term of legal art. So we'll give you both credit for that. All right, very good. Probable cause. You gotta have probable cause. I mean, that's just the buzzword. When somebody's using the word probable cause, I know that they're talking about the Fourth Amendment, because it just goes hand in hand. Okay? So when you say reasonable cause, I know what you're talking about, but you're going to see people on TV, they're going to be using words like probable cause, and I want you to make sure that you know what they're talking about. All right, so last week, the reason that I'm talking about all of that is because last week, because every week there's something. Last week there was a whole bunch of scuttlebutt. Something was gonna happen. Everybody was waiting for this thing to happen. I'm waiting on one person to raise their hand and tell me what it was. Yes, ma'am.
Is it the memo?
Yeah, the memo. Yes, the GOP memo was coming out.
I think it's terrible.
Tonight, the president and Republicans leveling a new broadside at the FBI with a 4-page memo alleging the Bureau abused its surveillance authority in seeking a warrant to monitor Trump campaign advisor Carter Page during the 2016 election.
It's been a tough fight.
The disputed memo, authored by the staff of House Intel Chairman Devin Nunes, claims that former FBI Director Andrew McCabe told the committee the Page warrant would not have been sought by the FBI without a dossier compiled on President Donald Trump's possible connections to Russia. 3 Democratic members of the committee, however, dispute that account, telling CNN that Nunes, quote, mischaracterizes what McCabe said.
The dodgy dossier.
The memo reveals that the warrant to monitor Page was approved and renewed by the court 3 separate times. The former Republican chair of the Intel Committee, Mike Rogers, says that would not happen without other U.S. intelligence to back up the application.
If this is all they used, well, the judge ought to get in trouble too, and I doubt that happened. I think there's a lot more information that supplanted the information that they provided. In addition, they went through separate renewals. In each renewal, according to the law, you actually have to confirm probable cause, meaning you had to get something off of that wire.
The memo also alleges that the FBI and Justice Department did not inform the FISA court that former British intelligence agent Christopher Steele, who compiled the dossier, was funded by the Democratic Party. Adam Schiff, the ranking Democrat on the committee, said that it is, quote, not accurate that the secret court was unaware of Steele's political motivations. He claims the court knew of, quote, a likely political motivation behind Steele.
What it ends up delivering is criticism of a single FISA application involving Carter Page and its renewals that cherry picks information that doesn't tell the reader the whole of the application, and is, as the DOJ and FBI have said, deeply misleading and factually inaccurate.
While the memo attempts to portray the FBI as relying on outside information to launch the Russia investigation, it notes that a counterintelligence investigation was actually opened months before the Page application, based on a stream of intelligence separate from the dossier. This includes information from the Australian government, which learned that another Trump campaign advisor, George Papadopoulos, have been offered damaging information about Hillary Clinton from an individual with ties to the Russian government.
Okay. Okay, so this is what the FISA statute, from our sources of law, this is by statute, a federal statute. That's where FISA comes from. Okay, so this is what it looks like. Now, there are 2 kinds of ways that this can be done. It can be done court order, i.e. warrant, or without. But the part that is talked about most so in the memo is this section here that deals with obtaining that surveillance with a court order. And look, it is done by ex parte order. This is what they call a secret court. And it's really for the purpose of, intelligence, counterintelligence, terrorism, that type of thing. And so it is used against a foreign power or an agent of a foreign power. The problem is that today, in today's political arena, people have started using this to do surveillance just on regular Americans. And they're trying to establish to a court that they are an agent of a foreign power. So we saw that guy, that Carter Page guy just now. Did he look like an agent of a foreign power? And so you can see here where it has the stampings on it showing that it is now unclassified or declassified. And it gives the facts of the concerns that this particular committee has. There is growing concern amongst Americans about how the FBI is using FISA.
Ed over at thehill.com talking about, did the FBI violate the Woods procedures in getting, embedding the FISA claims? Explain, first of all, what Woods procedures are.
Let me just say why this applies in the big picture to what happened to me and other people that haven't been revealed yet. The surveillance abuses that we are now seeing are tied into, I think, a pattern of 10 to 20 years of bad actors in the intelligence community that I've been told by sources have been presenting bad evidence to the FISA court, but it's never seen, so we don't know that. To obtain illegal warrants or warrants that would not otherwise be granted. There are other surveillance abuses that allegedly occurred. I think this is all connected. And the reason they didn't want Donald Trump, it's not so much his political positions and how much they hate him. He was the one guy that once elected, they feared would come in there and peer at what they've been doing the past 10 to 20 years. That's why, yes, it's bigger than the 2016 election. It's why did they do that?
Right.
And
go ahead.
The Woods procedures say, my read of it, you can read for yourself, you're not allowed to present a single unverified fact to the FISA court. Doesn't matter how much they relied on it, not a single unverified fact.
Why did the dirty dossier get into their hands?
That's the question. I had two high-ranking sources who worked under Obama, and one of them also worked under Clinton and Bush, who both separately contacted me when they heard this news and said criminal. I didn't ask the question, they both said criminal.
Wow, so if you present something and you have a footnote at the bottom that says presented by a political organization, that's not enough. And you gotta, well, we don't know what happened in that room. Do you believe, Cheryl, that the New York Times request, along with that, the request that's put forward from Congress, will get the transcripts out and find out what took place for the first time ever between that judge, or those judges, and those, and the FBI?
It depends, will Congress press to do it? Will there be a lot of opposition and squawking about it? Again,
The New York Times wants it.
Yeah, another intelligence source of mine said, this is now a legitimate pretext to look at all of the FISA activity that's occurred over the past 10, 20 years. I don't think that's going to be done. I think it ought to be done.
Yeah, pulling back the curtain, we want to see what really happened.
These are people on the inside saying this. These are intelligence-connected people, not outside.
If the FBI presents those cases, there's no defense attorney to say, push back. We shouldn't look at Cheryl's text message or Carter Page's phone call.
I'm not sure people realize this is one of the most serious violations of privacy you can do to an American citizen is wiretap. And it may not be done on a suspicion, out of curiosity, because you think they might have done something bad because you don't like how they're acting. You have to bring to the court verified evidence you gained through other means to justify the electronic surveillance of them. It's a very strict process. The president even has a certification authority that has to certify off on these. 3 of the 4 wiretaps, I believe, were signed by a certification authority under President Trump. Did his certification authority tell him that this was happening? And who was his certification authority?
Exactly. What did they say? All right, Cheryl, thank you very much for bringing all that to us. And once again, you can read the op-ed at thehill.com.